All right, so let's dive right in. Today we're tackling civil trial procedures in India.
Oh, interesting.
Yeah, and it might sound a bit dry at first, those legal terms and procedures,
Yeah.
but it's actually really fascinating when you think about it. It's about, how disputes actually get resolved, how rights are protected, and ultimately, how justice is served in a very practical sense.
Yeah.
So we've got these excerpts from the Jharkhand Judicial Academy's Civil Trial 2020 book.pdf. It's a pretty dense document,
Okay.
but it gives us a really good, foundation to kind of break down this whole process.
I see.
So imagine this. You're facing a legal issue, right? And you need to take someone to court.
Okay.
Where do you even begin? It could be pretty overwhelming, right?
Yeah, absolutely daunting.
Yeah, so where do we start?
Well, like most things in the legal world, it all starts with a document.
Okay.
In this case, it's called the plaint.
The plaint, okay.
Yeah, and it's basically your opening statement. You lay out your grievances, what happened, and what you're hoping to achieve.
So it's like setting the stage for your legal battle, right?
Exactly. And according to Section 26 of the Civil Procedure Code, it needs to be pretty specific. You have to outline the facts of the case, what caused the issue, and the solution you are looking for.
Okay, so you can't just show up and be like, this person wronged me. You have to,
Right, exactly.
have your ducks in a row.
Exactly. And here's where it gets even more serious.
Okay.
The plaint now requires what's called an affidavit.
An affidavit.
Yeah, so you're basically swearing under oath that everything you've stated is true.
Wow, so it's not just about telling your side of the story. It's about, being absolutely certain that the facts are accurate.
Exactly. The stakes are higher now.
Okay. But what happens if you, forget something? You miss one of those mandatory documents that are mentioned in Order 7, Rule 14. Is your case, automatically thrown out?
Well, not necessarily. I mean, the court might give you a chance to fix the error.
Okay.
But it just goes to show how important it is to be really meticulous right from the beginning. This isn't just a casual conversation. It's a legal process with very specific rules.
Right, consequences.
Exactly.
Preparation is key.
Yes.
So before we move on, can you clarify something that I think a lot of people get confused about? The difference between civil and criminal law?
Sure. They both deal with justice, but in different ways. Criminal law is about offenses that harm society as a whole, things like theft, assault, murder.
Okay, so those are crimes against the state, against the public order.
Exactly, and the goal is to punish the offender and deter others from committing similar crimes. The state brings the case, and they have to prove the guilt beyond a reasonable doubt.
And the consequences may be very serious, right?
Yes, prison time, fines, a criminal record, it's a big deal.
So civil law is different.
Yes, civil law focuses on disputes between individuals or organizations.
So breaches of contract, property disputes, things like that.
Exactly. It's about private rights and obligations, and the goal is to provide a remedy to the party who's been wronged, not necessarily to punish.
So the focus is on making things right between the parties.
Exactly.
And the burden of proof is lower than in criminal cases.
That's right. It's balance of probabilities, meaning it's more likely than not that the claim is true.
And the consequences are also different, right?
Yes, usually financial compensation, specific performance or injunctions, no prison time. It's about restoring balance and fairness.
But sometimes the same act can be both a crime and a civil wrong, right? Like assault, for example.
That's right. You could have a criminal case for the assault itself and then a separate civil case for the damages caused by the assault.
So two different legal processes for the same act, each serving a different purpose. That's fascinating. I've heard it said that choosing the right court can be half the battle, right?
Oh, absolutely. Not all courts can hear all cases,
Right.
India has this system of territorial jurisdiction, meaning certain courts are designated to handle specific types of disputes based on things like the location or where the defendant lives, or the amount of money involved.
So it's like a legal puzzle, figuring out where your case fits in the grand scheme of the court system.
Exactly. It can be a bit tricky, but luckily the Civil Procedure Code gives some guidance. Like Section 16, for example, says that you can file a suit where the defendant resides or works or conducts their business, so there might be a few options for you.
Okay, options are good, but I have a feeling it's not always that straightforward, right?
You're right, it can get a little more complex. Section 17, for instance, adds another layer, especially when it comes to cases involving immovable property.
Okay.
So imagine you have a property dispute, right? And the land involved crosses over into multiple districts.
Uh-huh.
Section 17 says that you can file the suit in a court where any part of that property is located.
Okay.
But here's the catch.
Uh-oh.
That court can only hear the case if it actually has the authority to handle the entire value of the claim. So if the property is worth, let's say, a huge amount, you might have to file in a higher court,
Ah, I see.
even if it means going outside of the district where the property is actually located.
It's like a jurisdictional maze.
Yeah.
One wrong turn, and your case could be delayed for who knows how long.
Exactly. So getting the jurisdiction right from the start is super important. It's like choosing the right battlefield. And once you clear that hurdle, you move on to the pretrial phase, which is all about laying that groundwork for your case.
Okay, so we filed the plaint. We're in the right court. Now what? What happens in this pretrial prep stage?
So this is where you really start to fine-tune your arguments. You gather all your evidence, talk to witnesses, that sort of thing.
Okay.
The goal is to minimize delays and get to the core issues as quickly as possible. Nobody wants a legal battle that just drags on forever.
Right.
So one way they try to speed things up is through Section 80 of the Civil Procedure Code.
Okay.
This requires, giving the government a heads up before you file certain types of suits.
Interesting.
So basically, it gives them a chance to review the claim and maybe even resolve it before it even goes to trial,
Oh, okay.
Prevents unnecessary litigation.
So it's like giving them a chance to say, whoa, hold on, let's talk this through before we go to court.
Exactly.
I like it. Efficiency is key.
Yes.
But what if there's like a problem with the plaint itself? Let's say it's missing some crucial information or it doesn't clearly state a valid claim. What happens then?
That's where Order 7, Rule 11 comes in.
Okay.
This rule basically gives the court the power to reject a plaint right at the outset if it's fundamentally flawed.
Oh, wow.
Yeah, and there could be several reasons for this, like maybe it doesn't disclose a cause of action or it's barred by limitations. So it really underscores the importance of having a well-drafted plaint, one that clearly articulates a valid legal claim.
So it's like the court saying, look, if you're going to come to us with a case, make sure you've got your act together, right? You got your ducks in a row.
Precisely.
You have all the information.
Yep. It's about ensuring that the court's time and resources are being used efficiently and that only strong cases proceed.
Now I understand why lawyers spend so much time crafting these documents,
Oh, yeah.
It's not just paperwork, it's the foundation
Exactly.
of your entire case.
It's like building a house. If the foundation is weak, the whole structure is at risk.
Exactly. Good analogy. So let's assume, our plaint is solid. We've figured out the jurisdictional maze, and we're moving towards an actual trial. This is where things get really interesting, right?
Yeah.
Witnesses, evidence,
Yes.
all the drama of the courtroom.
Exactly. The heart of any trial lies in the evidence, and the Indian legal system has, a very specific process for how this all unfolds. But before we go there, let's clarify one thing.
Okay.
Summoning witnesses in India, it's not automatic.
Oh, okay.
It's not like, you can just expect everyone, to just show up and vouch for you.
Got it. So there's a process. It's not like a free-for-all where anyone can just waltz into the courtroom and share their opinions.
Right. You need to convince the court why their testimony is crucial. Why do they need to be there? What specific information can they provide?
Okay. So it's about demonstrating relevance.
Exactly. And then once a witness is summoned, the way they give their testimony is also kind of evolving. Traditionally, they'd give their entire testimony orally, up on the stand. But increasingly, Indian courts are using what's called an affidavit for that initial stage of testimony, known as examination in chief.
So instead of a dramatic courtroom scene with a witness on the stand, they submit a written statement.
Yes, sworn under oath, right?
Okay. That seems a lot more efficient, I guess.
It is. It definitely streamlines things. But remember, the judge always has the power to call a witness for in-person testimony, if they need clarification or further questioning.
So it's a blend of traditional and modern approaches, finding a balance between efficiency and ensuring that thorough examination.
Exactly.
It's pretty cool how the legal system is constantly adapting, right?
Yeah, for sure. The quest for justice requires both sticking to established principles, but also adapting to new methods.
Well said. So let's say you've won your case, The court's issued a judgment in your favor.
Right.
But how do you actually enforce that judgment? It's not like the losing party just automatically hands over the money or the property, right?
You're right. Getting the judgment is just the first step. Turning it into a tangible result, now that requires what's called execution.
Execution.
Yes.
Tell me more. How do you actually make sure that court's decision gets implemented?
Well, the specific steps really depend on the type of decree the court issued. For example, if the decree is for, payment of money,
Okay.
the court might order what's called an attachment and sale of the judgment debtor's assets. So basically, they take their assets to satisfy that debt.
So if someone refuses to pay up, their property could be seized and sold to cover the amount that they owe.
Exactly. The court has the power to enforce its judgments.
Okay.
And if the decree involves delivering a specific property, like, a house or a piece of land, the court would issue an order.
Okay.
It's called for delivery of possession.
Okay.
And this directs the judgment debtor to hand over the property to the rightful owner.
Okay. And if they still refuse?
Well, then it gets tricky, right?
Yeah. Do they go to jail?
Well, not in all cases, but in certain situations, particularly when the decree involves a mandatory injunction and the defendant just continuously defies the court's orders, yeah, they might face what's called detention in civil prison.
Civil prison. Okay, that definitely highlights the importance of respecting court orders.
Absolutely. But even in these situations, the defendant always has the right to be heard. They can challenge those execution proceedings, raise objections, and seek remedies. It's all about finding a balance between enforcing judgments while protecting individual rights.
Yeah, making sure it's a fair process.
Exactly. And one crucial safeguard here is Order X-1, Rule 22.
Okay.
This rule says that if there's a delay in executing a judgment, the court has to issue a notice to the defendant.
Okay.
So even if someone is facing potential imprisonment for defying a court order, they still get a chance to explain themselves.
Right. They get a chance to be heard. It's about fairness and transparency, making sure everyone has a voice.
Exactly. Remember, the goal is always to uphold justice. And that includes giving everyone a fair chance.
It's remarkable how intricate the system is, with all these checks and balances built in at every step.
It is quite a complex system.
Yeah,
But it's fascinating, right?
it is.
How it all works together.
Yeah. And for our listeners, who may be feeling a bit overwhelmed, remember, this is just a glimpse into a vast and complex world. But even this little glimpse, can empower you to better understand your rights and navigate the legal system.
Absolutely. And knowledge is power.
Yes.
The more you understand about the legal system, the better equipped you are to protect yourself and those around you.
Yeah, that's a powerful thought to leave our listeners with. But don't go anywhere yet. There's so much more to explore.
It's amazing how the system tries to balance being strict with the rules, but also being compassionate at the same time.
Yeah, you're right. It's like they recognize that there are real people with real emotions behind every case. But I'm curious, we've been talking about the procedures, the safeguards, all that, but what about the actual people involved?
Right.
What are their roles in this whole drama?
Well, think of a courtroom as a stage and the trial as a performance, right?
Okay, I like it.
At the center of it all, you have the judge presiding over everything, interpreting the law, and ultimately, making the final decision.
So the judge is like the director.
Exactly, making sure everything runs smoothly and according to the rules.
Okay.
And then you have the lawyers representing each side,
Right.
presenting the arguments, questioning witnesses, really fighting for their client's best interests.
So they're like the actors, each trying to, persuade the judge and win the case.
Exactly. And then you have the witnesses.
Right, and we talked about that a role earlier.
Yeah, with affidavits and all.
But there's still something powerful about that live testimony, right, when they're on the stand?
Oh, absolutely. Live testimony, that can be really compelling. The way a witness answers a question, their body language, all of that contributes to the judge's understanding of the case.
It's like a real-life drama unfolding, right there in the courtroom.
Exactly. And Indian civil law offers a variety of remedies. Each one is kind of tailored to a specific type of wrong.
Okay.
One of the most common remedies is monetary compensation,
Okay.
often referred to as damages.
Damages. Okay.
Yeah, so if someone breaks a contract, or causes harm through negligence, they can be ordered to pay money to compensate for those losses.
So it's like you messed up, now you got to pay to fix it.
Precisely. And damages can be awarded for all sorts of losses: financial losses, physical injuries, emotional distress, even damage to reputation.
It's interesting how the law tries to put a price tag on those things.
Right. Quantify harm. But what happens when money just isn't enough?
Yeah, good question.
When the wrong involves more than just a financial loss?
Right. What then?
Well, that's where other remedies come into play.
Okay.
One of these is called specific performance.
Specific performance. Okay.
And this compels the party to fulfill their contractual obligations. So instead of just paying money, they have to actually do what they promised in the contract.
Oh, okay. So it's about making sure actions match the words.
Exactly. And this is often granted in cases involving, unique things, like, for instance, a contract for a piece of land.
Right. Something irreplaceable.
Exactly.
Where money wouldn't really cover it.
Right.
So it's really about restoring the aggrieved party to where they should have been.
Exactly. Making them whole. And of course, we have injunctions.
Right. We talked about those earlier, those court orders that can either stop someone from doing something or make them do something.
Exactly. They prevent future harm, or they can require action to correct a wrong.
So they're a pretty versatile tool for the courts.
Oh, yeah, very flexible. They can really tailor solutions to fit each specific case.
It's like the court has a whole toolbox of remedies.
That's a great way to put it. The goal is to find the most effective and just remedy, the one that truly addresses the wrong and restores that balance.
Let's talk about this concept of costs.
Okay.
What does it actually mean when a court awards costs to one of the parties? It's not just about the court fees, right?
You're right. It's broader than that. It's about compensating the winning party for the expenses they incurred during the case.
So it's like reimbursement for legal fees, expert witness fees, all those things that add up during a trial.
Yes, but it's not always a full reimbursement. The court has some discretion in determining what are reasonable costs. They might award only partial costs or even deny costs altogether.
Ah, so there's some subjectivity involved.
Exactly. They look at various factors. How complex was the case? Was there any attempt to settle outside of court? Did one party act unreasonably? Things like that.
So it's like the court is encouraging people to be reasonable and act in good faith.
Exactly. The concept of cost is also there to discourage frivolous litigation and promote settlements.
So it's not just about winning or losing.
No.
It's about how you conduct yourself throughout the process.
Exactly.
And what happens when the court decides not to award costs? What's the message there?
Well, it often signals that while one party may have technically won, maybe something in their conduct wasn't entirely right.
So it's like a subtle message from the court saying, hey, look at how you handled this.
Yeah, it's about fairness, even in victory.
Right. It adds a whole other layer to this legal chess game. So most cases probably don't actually go all the way to a full trial, right?
You're right, it's don't.
There must be ways to resolve things beforehand.
Absolutely. The Indian legal system really encourages what's called alternative dispute resolution.
Okay.
This includes things like mediation, where a neutral third party helps both sides reach an agreement.
So it's less about fighting and more about finding common ground.
Exactly. It's often faster, less expensive, and it can help preserve relationships.
Right, because nobody wants a legal battle to turn into a lifelong feud.
Exactly. And the law actually recognizes the value of this approach.
Okay.
Order 23 of the Civil Procedure Code, for example, specifically deals with compromises and withdrawals.
Okay.
It allows parties to settle their disputes amicably at any stage of the proceedings.
So even if the trial has already begun, they can still decide, you know what, let's just shake hands and walk away.
Exactly. As long as the compromise is lawful, doesn't violate any public policy, once that compromise is reached, it's recorded, and the court issues a decree based on it.
So the court gives its stamp of approval, makes it official, but what if someone tries to back out later? Can they change their mind and demand a trial after all?
Not so easy.
Okay.
Order JIC 3, Rule 3 is clear on that. Once that decree is passed based on a compromise, it's pretty much final.
Okay, so it's about upholding agreements, making sure people stick to their word.
Exactly, encouraging accountability. But of course, if there's a genuine issue with the compromise, like if someone feels they were coerced or the terms are unfair,
Yeah.
the court will examine the agreement very carefully.
So it's not just a rubber stamp.
No, the court acts as a safeguard.
Making sure the compromise is fair,
Exactly.
that's reassuring. Even when people resolve things on their own, the court is still there to make sure it's done right. What kind of conditions would justify such a measure?
Well, the plaintiff has to show very strong evidence, usually through an affidavit, convincing the court that the defendant is likely to, try to evade the proceedings.
So not just suspicion, right?
No, concrete proof. And even then, there are safeguards in place.
Of course, there are always safeguards.
The court might require the defendant to provide some kind of security, to guarantee their appearance in court.
Okay, so it's like saying, we trust you'll do the right thing, but just in case.
Exactly. It's all about finding that balance, protecting the plaintiff's interests, but also ensuring the defendant's rights are protected.
A delicate balancing act, for sure. And this seems to be a recurring theme, and this idea of balance. It's like every aspect of the Indian civil justice system is about balancing different interests and making sure everything is fair.
Absolutely. It's complex, but ultimately it's about ensuring justice is served, not just efficiently, but equitably.
Well said. And speaking of equity, let's talk about this concept of natural justice. It sounds very philosophical.
It does.
But what does it actually mean in a courtroom?
So natural justice is really about ensuring fairness and impartiality. It boils down to two key principles. One is audi alteram partem, which means hear the other side.
Okay.
And the other is nemo judex in causa sua, which means no one should be a judge in their own case.
Okay, so it's about giving everyone a fair chance, making sure decisions are made without bias.
Exactly. And these principles are woven into the fabric of the Indian legal system. For example, the very act of serving summons on the defendant,
Right.
That's about giving them notice, letting them know what they're facing.
So they're not caught off guard.
Exactly. And then the right to cross-examine witnesses, challenge evidence, all of that is about ensuring a fair hearing. It's not just about telling your side, but making sure the other side is also scrutinized.
Right, it's like saying, don't just tell me, show me the evidence.
Exactly. And then there's the principle of impartiality.
Right.
The way the Indian judiciary is structured emphasizes an independent and impartial judiciary.
Okay.
Judges are expected to be neutral, making decisions based on the law and the evidence, not their personal opinions.
And what if there are concerns about a judge's impartiality, like a conflict of interest?
Well, there are mechanisms in place to address that. A party can request a judge to refuse themselves from a case if there's a perceived conflict.
So it's not just about being impartial, it's about appearing impartial, maintaining that public trust.
Exactly. Natural justice is not just about following procedures, it's about upholding fundamental values.
Okay, so let's move on to another tool used to ensure justice. Injunctions. I always picture a judge slamming their gavel, ordering someone to stop doing something.
Yeah, it's a bit more nuanced than that, but you're right. Injunctions are powerful tools.
So what are they exactly? And what different types are there?
Well, injunctions are basically a court order that requires a party to either do something or refrain from doing something. It's used when someone's rights are being violated, and simply awarding money wouldn't be enough to fix the situation.
So the court steps in to prevent further harm, or maybe to preserve things while they figure out what's going on.
Exactly. There are a couple of main types of injunctions. You
Okay.
have temporary injunctions,
Temporary, okay.
which, as the name suggests, are short-term measures just to hold things steady while the case is being decided. And then you have permanent injunctions.
Okay, so that's after the trial is over?
Yes, it's the court's final say. But what if the court wants someone to actively do something,
Good point.
not just stop doing something?
Okay.
That's where mandatory injunctions come in.
Mandatory injunctions, okay.
These require a party to take specific action, to fix a wrong, like maybe to tear down an illegal structure or to fulfill their obligations under a contract.
So injunctions are pretty versatile.
Very much so.
The court can really tailor solutions.
Right.
But I imagine there are strict criteria that have to be met before an injunction is granted.
Oh, absolutely. They're not given out lightly. Order X69 of the Civil Procedure Code outlines those principles.
Okay.
So the applicant has to show that their rights are being violated.
Right, they can't just say it, they have to demonstrate it.
Exactly. And they have to show they would suffer irreparable harm if the injunction isn't granted.
Irreparable harm, okay.
Meaning the damage would be so bad that money can't fix it.
Wow, that's serious.
It is. And the court also considers the balance of convenience, so they weigh the harm to the applicant against the potential hardship to the other party.
It's like trying to find a balance point on a seesaw.
Exactly. It's a careful consideration of everyone's interests.
Right, because granting an injunction can have serious consequences for everyone involved.
Absolutely. So courts are very cautious.
Now let's talk about receivers. What are those?
Receivers, oh, they're like the court's appointed caretakers.
Caretakers.
Yeah, they're appointed to manage and preserve property that's under dispute, to make sure it's protected while the legal battle is going on.
So it's like the court saying, we need someone neutral to watch over this valuable thing until we decide who gets it.
Exactly. Order XL of the Civil Procedure Code gives courts this power. It's about preventing any misuse or damage to the property.
Makes sense, especially when emotions are running high.
Oh, yeah.
Someone might be tempted to, do something rash.
Exactly.
So what do receivers actually do?
Well, they might collect rents, if applicable. They maintain the property, safeguard its value. They're accountable to the court and have to regularly report on their actions.
So it's a serious responsibility.
It is, and they can be held accountable for any mismanagement.
Good to know. Accountability is key. Now, we talked about how enforcing judgments is important.
Right.
So how does that execution process actually work? What are the steps involved?
Well, that's detailed in Order X61 of the Civil Procedure Code. The specific steps depend on what the judgment says.
Okay.
If it's about paying money, they might seize and sell the debtor's property.
Right, we talked about that. But what if it's about handing over a specific property, like a house?
Then the court will issue an order for delivery of possession,
Okay.
basically telling the person to hand over the property to the rightful owner. And if they refuse, well, the court can authorize the use of force, if necessary.
So they could be forcibly removed. Wow.
Yeah, the court means business.
But what if the person has absolutely nothing, no assets to seize? Can they just get away with it?
Not necessarily. In those cases, the court might issue a warrant for their arrest.
Arrest.
Yes, and detention in civil prison.
Civil prison.
Yes. It's a last resort, but it shows how seriously the court takes these matters.
But as always, I'm sure there are safeguards to prevent abuse.
Absolutely. The person can challenge the proceeding, raise objections. The court wants to make sure everything is done fairly.
Okay, good.
It's all about balance, upholding the rule of law while protecting people's rights.
But we also have to acknowledge the human side of all this.
Oh, for sure.
It can't be easy going through something like this.
It's a stressful and emotional process, absolutely. That's why courts often encourage parties to try and find amicable solutions, even during the execution phase.
So sometimes it's not just about strictly enforcing the rules.
Right. It's also about finding a resolution that takes into account the human impact.
So it's about fairness, but also about compassion. Now, let's dig a little deeper into the concept of fair trial. We've touched on it throughout this discussion.
Okay.
But what does it really mean in the Indian context? What are the key elements?
Well, the right to a fair trial is actually enshrined in Article 21 of the Indian Constitution. It's a fundamental right.
Wow, so it's not just a nice idea, it's part of the foundation of the legal system.
Exactly. It ensures that everyone has an equal opportunity to present their case and receive a fair judgment.
And what are the specific elements that make a trial fair?
Well, first and foremost, you have the right to be informed about the case against you. You have to understand the allegations, you have to have access to the evidence, all of that.
So no surprises, right?
Right. You also have the right to legal representation, to have a lawyer there to advocate for you and guide you through the process.
That's crucial, especially in a system as complex as this one.
Absolutely. And access to legal aid is essential so that even those who can't afford a lawyer can still have their rights protected.
Right, because justice shouldn't depend on how much money you have.
Exactly. Another crucial element is having an impartial and independent judge, someone who will base their decisions solely on the facts and the law without bias.
So no personal opinions influencing the outcome.
Right, and you also have the right to cross-examine witnesses, to challenge the evidence presented against you.
Okay, so it's about making sure the evidence is reliable, that the court has the whole story.
Exactly. And finally, you have the right to a reasoned judgment. The judge has to explain their decision.
So it's not just a verdict, it's an explanation of how they reached that verdict.
Exactly. Transparency and accountability. It's about ensuring that the decision-making process is clear and justifiable.
It all comes back to fairness, doesn't it? So let's talk about the impact of technology on all this. I imagine technology is playing a big role in shaping how these trials are conducted.
Oh, absolutely. It's revolutionizing the legal landscape in India, just like it's changing everything else.
So what are we seeing? Online filing systems, virtual hearings?
All of that. One of the biggest changes is the introduction of e-courts.
E-course, okay.
This allows people to file cases online, pay court fees, track their case status, all without having to physically go to the courthouse.
Wow, so no more standing in line for hours.
It's definitely making the system more accessible and user-friendly, especially for people in remote areas or those who have difficulty traveling.
That's great. It's about bringing justice to the people, not the other way around.
Exactly. And then there's the rise of virtual hearings.
So lawyers and litigants can participate in hearings remotely through video conferencing.
Yes, it saves time and money and makes things much more efficient.
But what about the human element? Doesn't something get lost when everything is done through a screen?
That's a valid concern, and it's something the legal community is grappling with. While virtual hearings offer a lot of benefits, we have to make sure they don't compromise the quality of justice or the solemnity of the process.
Right, it's about finding that balance again.
Exactly. We need to make sure everyone has reliable internet access, that proceedings are kept private, and that the decorum of a courtroom is maintained.
It's a new frontier, for sure. And technology's impact goes beyond just the procedures, right?
Right.
What about the evidence?
Well, we're seeing a lot more digital evidence being used.
Like emails, text messages, social media posts, that kind of thing.
Exactly. It reflects the way we live now. So much of our lives is online.
Right.
But it also presents new challenges. How do we ensure the authenticity of that evidence? How do we know it hasn't been tampered with?
Great point. And there are probably privacy concerns as well.
Absolutely. So the legal system is constantly evolving to keep up with these technological advancements.
It's like a race between technology and the law.
In India, while the civil justice system is mostly codified, meaning the laws are written down in statutes,
Okay?
precedent still plays a very important role in interpreting and applying those laws.
So it's a combination of written law and judicial interpretation.
Exactly. And higher courts like the Supreme Court and the high courts, they set precedents that lower courts have to follow.
So it's like a hierarchy of authority.
Right. The higher courts guide the lower courts. It creates a system of judicial discipline and makes sure the law is applied consistently across the country.
Okay, so precedent provides stability and prevents things from becoming chaotic.
Exactly. But it's not completely rigid.
Oh, okay.
There are times when courts can deviate from precedent.
Really? When would they do that?
Well, one scenario is if the Rangers decision was just plain wrong, maybe based on a misunderstanding of the law.
So if a court realizes a mistake was made, they can correct it.
Yes, it's about making sure justice is done, even if it means challenging an old decision. Another reason might be if society's values have changed significantly, and the old precedent no longer reflects what's considered fair or just.
So the law adapts to the times.
Exactly.
So what are some of the challenges and criticisms that the civil justice system in India faces?
Well, one of the biggest criticisms is the issue of delays. Cases can drag on for years, sometimes even decades.
Wow.
Yeah, and it can be really frustrating for everyone involved, tying up resources, causing stress.
And what contributes to these delays? Is it just too many cases, not enough judges?
It's a combination of factors, really. Some of it is procedural, like the multiple stages of appeals. While these are important to ensure fairness, they can also slow things down.
Right.
And then there are issues with court infrastructure. Many courts are overburdened. They have a huge backlog of cases, and there's a shortage of judges to handle all the work.
It's like a traffic jam in the legal system, with everyone stuck waiting.
Exactly. And of course, there's the issue of affordability. Litigation can be expensive, and not everyone has access to quality legal representation.
Yeah, especially for people from marginalized communities.
Exactly. It raises questions about equality and access to justice.
Right, because if the system isn't accessible to everyone, is it really serving its purpose?
That's the key question. Thankfully, there are efforts being made to address these challenges. There are reforms, initiatives to streamline things, increase the number of judges, and provide legal aid to those who can't afford it.
That's good to hear. It's a work in progress.
It is, always evolving. Let's talk about something really unique to the Indian system, public interest litigation, or PIL.
Okay, PIL, I've heard of that.
So PIL basically allows any concerned citizen to go to court on behalf of a group of people whose rights are being violated.
So if a community is facing injustice, but they're unable to take legal action themselves,
Exactly. Someone can step up and fight for them.
that's amazing.
It is. PALs have been used to tackle all sorts of issues like environmental pollution, human rights violations, consumer protection.
So it's about empowering people to address issues that affect the common good.
Precisely. It's a tool for social change, and it shows how the legal system can be used to protect not just individual rights, but also the well-being of society as a whole.
Well, I think this has been an incredibly insightful journey into the world of civil trials in India. It's obviously a complex system with a lot of moving parts, but it's fascinating to see how it all works together to uphold the rule of law and protect people's rights.
It's been a pleasure discussing it with you. The key takeaway, I think, is that understanding even the basics of civil procedure can be very empowering.
Right? It gives you the knowledge and the confidence to navigate the system, protect yourself, and seek justice when it's needed.
Exactly. And as we've seen, the Indian legal system is constantly evolving, adapting to new challenges, and striving to ensure that justice is served fairly and effectively.
And for our listeners, we encourage you to continue exploring and learning about your legal rights and the resources available to you.
Absolutely. Remember, justice is not just a concept. It's something we all have a role in upholding and promoting.
Well said. And on that note, we want to thank you all for joining us on this deep dive. We hope you found it informative and insightful. Until next time, keep learning, stay curious, and remember, justice is a journey, not a destination.